Yesterday, somebody asked me to do a video on the concept of evidence being more prejudicial than probative. Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. Until the judge declared that we wouldn't have any trial today, I didn't know when I was going to work that in. But since it's fresh in my mind, and since we have this opportunity to do a video on a subject that I know a little something about, I'm going to happily do that today, and we'll do that in the context of the Karen Reed case. In every trial, the judge has to balance two things. Is the evidence important to proving a point? In other words, is the evidence relevant? And is it going to inflame the jury so much that they forget to be fair in judging it? That's the core of the more prejudicial than probative rule. Sometimes powerful evidence is just way too powerful in the wrong way. Think of it like watching a debate between two politicians. They're discussing an economic issue and whether to cut taxes. The debate centers around the proper economic principles to apply to the problem at issue. Suddenly, one of the politicians says, "In your divorce, your ex-wife claimed you slept with someone half your age, so don't talk to me about economics, you can't count." Well, it's a funny line. It has nothing to do with the issue. It gets attention, but it also clouds judgment. It makes people prone to judge on moral grounds, act on emotion rather than reason. And essentially, that's what judges are trying to prevent by weighing whether evidence is more prejudicial than probative. And the principle that the evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice is embodied both in the Federal Rule of Evidence 403 and the Massachusetts Rule of Evidence Section 403. The shorthand of more prejudicial than probative is shorthand that does violence to the rule. Here's why. Section 403 says the court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. However, prior bad act evidence should be excluded if the court finds that its probative value is outweighed by the risk of unfair prejudice to the defendant, even if not substantially outweighed by that risk. In other words, if you're trying to introduce bad character evidence, you have to just have a slight balancing. It doesn't have to tip the scales all the way down. Now, Massachusetts has a series of comments to the rule, and on the one on unfair prejudice is especially important to understand because it makes a good point right at the beginning. Relevant evidence is presumed to be prejudicial or harmful to the party against whom it is offered, but exclusion is only warranted when the prejudice is unfair. That's Commonwealth versus Kendall, a 2013 case from the Massachusetts Appellate Court. Unfair prejudice may result when jurors are unnecessarily exposed to inflammatory evidence that might cause them to decide the case based on emotion. In that case, Commonwealth versus Cruzado, the use of a racial slur relevant to show motive, the judge mitigated the prejudicial effect by conducting individual voir dire of prospective jurors on whether the evidence would create bias. Commonwealth versus Bishop, a racial slur presumptively poses a risk of unfair prejudice such that before a judge admits evidence that a defendant used this word to describe a person of color, the judge must be convinced that the probative weight of such evidence justifies the risk. In other words, it has to be more relevant on an issue of proof in the proceeding, for example, a hate crime, than it would be of other evidence. And then in Garth versus MACOM, Massachusetts case, a civil case, Evidence of arguably intentional spoliation of evidence, that was relevant to two central issues in the case was not unfairly prejudicial. In other words, the fact that certain evidence was destroyed or was, they call it spoliated, but basically it means spoiled. There was some attempt to hide evidence from the jury. While that's prejudicial, it was not unfairly prejudicial. Unfair prejudice also may result when the trier of fact considers evidence properly admitted for a limited purpose for an impermissible purpose. So, for example, when something is not admitted for the truth of the matter asserted, when it's hearsay, but it's not admitted for the truth of the matter, but rather to show state of mind or something like that. That's a situation where if somebody uses it for an impermissible purpose, for example, convicting someone, that would be a violation. Evidence of defendant's gang affiliation properly admitted to establish motive for killing a non-propensity purpose created risk of unfair prejudice where jury was permitted to consider evidence on the issue of guilt or innocence with no limitations. So that's how Massachusetts courts tend to apply this rule. Understanding how other courts around the country have applied Rule 403 and its close cousins is instructive. First of all, courts consider these factors: the strength of the probative value. In other words, is the evidence directly tied to a material evidence in dispute? Is there an alternative, less prejudicial way to prove the same point? For example, having the defendant stipulate to something. Potential for unfair prejudice. Will the evidence cause the jury to decide based on emotion, not reason? Politicians do this up all the time when they insist on talking about conduct that isn't unlawful but is unseemly. They're working that emotional angle. And you should always be wary when somebody wants to make you emotional because it is clearly an attempt not to let you reason through or think through a proposition. Does it provoke an improper or visceral reaction? Here you want to think about gruesome photos. There are lots of people who are killed in very awful ways. It may be necessary to show, for example, where the body lays, but it's not necessary to go through all of the cuts and things that were made at autopsy. So there is a balancing there on this particular part that I see courts do a whole lot. The likelihood of confusing or misleading the jury. Sometimes evidence is difficult to interpret. Is it likely to mislead? Here in this Karen Reed case, we have all this evidence about key-on events and what the car's infotainment system shows. The infotainment system was never meant to be an evidentiary tool. Rather, it's just keeping track of stuff, and I'm pretty sure that manufacturers download this stuff and use it for marketing. But by virtue of the fact that it's captured, the state is going to use it. Now, the question is it difficult to understand or interpret, and is it likely to mislead the jury? It certainly could. Undue delay or cumulative nature. Does the evidence repeat what's already been proven? One of the things that the state did the first time in the Karen Reed case, according to people who watched it, is that they just proved everything. They proved up every witness, brought every witness out and had them tell their story, and it took forever and a day to get through the trial. There is no need to prove that someone is dead 16 times. Rather, what you need to prove is something different and something that will keep the jury in tune with what's going on. Undue delay works against both parties, and cumulative evidence works against both parties in a criminal case. So, examples of where evidence was excluded. There is a case from 1997, Old Chief versus United States, 519 U.S. 172. The defendant was charged with being a felon in possession of a firearm, and he offered to stipulate to the fact that he had a prior felony conviction. But the felony conviction was just too good to bypass. So the prosecution insisted on presenting the name and nature of the prior conviction: assault causing serious bodily injury. Supreme Court held that admitting the nature of the prior conviction was more prejudicial than probative. Since the fact of the felony was not in dispute, the government had no need to present the inflammatory details of that prior felony conviction. And the key quote from the case: the name of the offense raises the risk of a verdict tainted by improper considerations. State versus Bocharski, 189 Arizona, 119, a 1997 case. In a murder case, the prosecution presented graphic photographs of the victim's body, and the body had not been well preserved. So there were all kinds of details. Without going into too much of it, there were just details that made this especially gross and ugly. And the Arizona Supreme Court ruled that the photos were unnecessarily gruesome and had little relevance to proving any disputed fact. So the evidence was excluded as its probative value was slight and it posed a high risk of unfair prejudice. You can't look at that kind of thing and not be affected by it. When I worked in healthcare, I worked in almost all areas of the hospital because, particularly in my later years, I was the director of cardiopulmonary services. And so I would be in the intensive care unit, the cardiac care unit, the emergency room. And in the emergency room, we saw a lot of children who came in who'd been the victims of child abuse. And when you see that kind of thing, there's no way not to be emotional. You know, a small child who is just, he doesn't have any ability to fight back. He has no way to protect himself. He has nobody in his corner. And there is this visceral reaction. That's the problem. I know that if I was asked to serve on a jury involving child abuse, I couldn't do it. I absolutely couldn't do it. And the reason is because it promotes that visceral reaction. Then there's United States versus Hitt. It's a 473 F 3rd 146. It's a Fifth Circuit case from 2006. The defendant was charged with possession of a firearm by a felon. The prosecution sought to introduce rap lyrics he had written that included violent and criminal themes. The Fifth Circuit found the lyrics to be prejudicial and of minimal probative value, especially since there was no direct link between the lyrics and the crime charged. So the crime is being in possession of this firearm and not using the firearm to hurt anybody. And that may have been what the lyrics to the song were all about. The conclusion: the evidence was excluded under Rule 403 due to the danger that the jury would convict the man based on bad character or perceived criminal lifestyle. People versus Holford, a 2012 case from California, 203 Calap 4th, 155. Facts: in a vehicular manslaughter case, the prosecution wanted to introduce a 911 call where a witness screamed and cried, but she was a testifying witness at the trial. The California Court of Appeals excluded the call, finding the emotional nature of the recording would likely inflame the jury and did not act to add materially probative value beyond the witness's trial testimony. So they said basically, look, you can prove that up when she's on the stand. You can ask, did you cry? Yes. Did you scream? Yes. Without having the jury listen to that. Again, it provokes a visceral reaction when you hear people scream in pain. Having worked in healthcare, I can tell you it provokes that reaction even with people who are hardened to it. United States versus McVeigh, the Timothy McVeigh trial from 1997. The prosecution in the Oklahoma City bombing case wanted to introduce highly emotional evidence of the kids' deaths in the daycare center. The trial judge excluded some of the most emotional materials, like autopsy photos, ruling that although the evidence was relevant, its emotional impact would unfairly prejudice the jury and risk undermining the fairness of the trial. As you can see, there are a lot of different ways that this rule comes into play in the courthouse. And one of the most important things the judge has to do is admit relevant evidence without admitting evidence that pushes well beyond relevance and into inciting kind of emotional reactions from people who are going to decide the case. I hope that provides some explanation of what more prejudicial than probative is. But remember, it's not just more prejudicial. It is it has to be substantially outweighed. In other words, the risk of unfair prejudice has to substantially outweigh the evidence and the probative value of the evidence. So if it's the only way to prove a particular fact and the fact is essential in the case, it's probably going to come in. Now, that doesn't mean that at the end of the day, there aren't things that the judge can do about this kind of evidence. And one of the things we heard earlier, where the judge interviewed the jurors and said, are you going to be able to handle this evidence? Are you going to be able to keep an open mind? Are you going to be able to set aside your emotions and decide this based on reason? And the jurors all testified that they could. So there are ways that judges have to deal with this issue that, in some ways, sets aside the prejudice that comes in. But as a defendant, you don't ever want to lose on this kind of motion, because if viscerally upsetting evidence comes in, the likelihood of a conviction goes up pretty significantly.
That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.